We are back on the record for hearings in case numbers 30869 through 30880. I am David Garner, hearing examiner for these hearings. We're at the hearing room for the Department of Mineral Resources, Oil and Gas Division, and it is 9 a.m. We'll resume where we left off, which I believe was with Attorney Broughton is going to call his next witness.
We'll get him on the phone real quick here.
Hi, Chris. You ready? Okay, I'll put you on.
And what's his name?
Well, we are calling Chris Stockness, appraiser with Shenahan Company.
Stockness is his last name? Okay.
Yes.
Mr. Stockness,
Morning.
do you solemnly swear or affirm under the penalties of perjury the testimony you're about to give in this matter will be true and correct to the best of your knowledge and belief?
I do.
Mr. Stockness, can you state your full name and spell your last name for us, please?
Yes, Christopher John Stockness, Stockness.
And can you tell us by whom you're employed in your position?
Yeah, I am employed at Shenahan Company, where I am the managing director of real estate.
Can you tell us just briefly what your educational background is?
Yes, I attended the University of St. Thomas and obtained a degree in real estate. And I'm a certified general real property appraiser that's been working in the valuation industry since 2002.
And can you just provide some general background on your professional experience as an appraiser?
Yeah, as I mentioned, I've been in the valuation industry since 2002. Out of college, I actually started at Shenahan Company, initially hired as a valuation analyst, and I'm currently the vice president, managing director of real estate at Shenahan. And Shenahan Company is a real estate and business valuation firm that's been in business since 1927. We're based out of Minneapolis, and we routinely complete assignments throughout the upper Midwest. Over the past 20 years, I've been performing a multitude of commercial real estate valuations ranging from land to all types of commercial real estate. In the course of my work, I'm routinely valuing different property rights, interests, including, fee simple, lease fee, surface rights, mineral rights, air rights, and various easements. I do also hold a full-time license as a certified general real property appraiser in the state of North Dakota, and I've testified as a valuation expert in the state.
Thank you, Mr. Stockness. We have an exhibit marked as LO-55. Do you have a copy of that in front of you?
Yes, I do.
And can you tell us what that is?
That's my curriculum vitae.
And does the curriculum vitae accurately represent your professional work and experience?
Yes, it does.
Move to admit Exhibit 55.
Any objection?
No objection.
The exhibit will be admitted.
Mr. Stockness, have you done any valuation projects or appraisal work that are similar or that you think would be helpful to assessing compensation for the matter that brings us here today?
Yeah. So as I mentioned, I have a license in North Dakota for appraising real estate, and I've worked throughout, central North Dakota, throughout the Bakken Formation, all across the state, really, appraising everything from easements for various pipelines. Been involved in some oil production valuation and surface rights, and including the impact of surface rights from energy production. Valued transload facilities and routinely value agricultural land throughout the state. As well as that, our firm does get involved in doing a lot of mineral rights valuation. One assignment in particular I'm currently working on is an underground natural gas storage assignment that we're working on in the in Iowa. And in that particular instance, we are involved in appraising what the value, what a lease agreement should be for the right to store natural gas underground.
And with respect to the intervener landowners in this matter and the time and work you've done, have you had time to put together a full appraisal for the valuation of pore space rights in the proceeding that brings us here today?
No, and this was something when I initially was reached out about this potential assignment. We had discussed, given the time frame of having to provide potentially a report and some valuation testimony by, today or by, for this hearing. And that was approximately 30 days ago. And I said, I really am not going to be able to complete any type of credible analysis. And so what I agreed to do was just begin doing some consulting analysis where we could study some of the appraisal issues related to the pore space in the Mercer and Oliver County.
And you mentioned a moment ago that your firm is working on a valuation and appraisal for pore space rights, or for, I shouldn't say, you said you were working on an appraisal for a gas storage facility. How long has the firm been working on that project approximately?
Yeah, we were first engaged on that back last fall, and we are just still kind of in the early stages of what I call kind of the research and fact gathering taking place. And one of the things that's particularly challenging with that assignment is finding the market data that you need to really understand, the market, and then apply that to what is, a fair market value on a storage agreement.
And what would you say is the approximate time frame to complete an appraisal on a valuation project as technical and complicated as valuing property rights as needed for a underground storage facility?
Well, so just to give you kind of a rough estimate, I mean, we're going to be spending 6 months here. We're already at 6 months, probably a year studying it. Now, we're not exclusively studying just that. Obviously, I have other assignments going on. But what we have to do is really reach out on kind of a national basis and see the kind of data we can gather. And so we've been working with that and trying to find other experts, other stakeholders, people that have been involved in these transactions. And oftentimes when you find some of these market transactions, it takes a while for you to verify all the information and really understand all of the physical attributes with that particular property and how the compensation or the payments were determined in a given instance. And then you, of course, have to pull all this data together, study it. And, this isn't something where you can just find a few different data points and then quickly reconcile to what a value is. And so you're looking and you're trying to find current data if you can, and also, understand as thoroughly as you can, verifying how the transaction came together. Was there some threat of eminent domain, or was it truly an open market transaction? And so that just takes time and a lot of digging to occur. And that kind of mirrors what I've been finding in this assignment over the last 30 days as I've started to get into it.
And as you started your work on this assignment, have you had an opportunity to review any transactions that you might end up using in an appraisal analysis?
Yeah. So far to date, we've had the opportunity to go through about kind of what I would say maybe around 20 potential transactions that we are beginning to kind of study and analyze. And so we're at kind of a good starting point. However, as we've gotten into these agreements, we're seeing a lot of variation. There's some market themes that are emerging. However, there's still a fair amount of variation within them. You know, for example, looking at, you know, what is the appropriate payment on a per metric ton? You know, we're seeing current data ranging from 25 cents per metric ton to 50 cents on the lower end, all the way up to $1.50 or more per metric ton on the upper end. And we're trying to really study to understand what are the reasoning behind that. You know, what are the physical reasons in terms of how those rates are determined? Are they looking at the quality of the storage space, or the density or volumetric ability you have of what you can store there, and how does that affect the price? We're also trying to extrapolate from that, like, locational characteristics. So in the example of the core-based agreement in Mercer-Oliver County, clearly you have kind of the infrastructure coming into place. And so, and a lot of ethanol plants in Iowa and the surrounding areas that you're going to be able to utilize the CO2. And so how does that impact when we're comparing it to a lease that's down in Louisiana or Texas or, you know, somewhere in like Illinois, which I'm just citing some of the data points we've been looking at.
And with respect to those agreements that you mentioned that you've been reviewing, in the exhibits that we marked exhibit numbers 32 through 53, and excluding exhibit 50, which is a study that's unrelated that was marked in the middle of those. But excluding exhibit 50, are exhibits 32 through 53 copies of the agreements that you've agreed thus far as part of this assignment?
Yeah, that essentially is kind of the data set we've been working from at this point. And our goal with that would be to collect more of that data. And some of it, I think the most recent is around 2022. And so one of the things I want to try to find is some more current data. Even though 2022 is relatively recent, we're dealing with an emerging market here. And so as this market is emerging and taking shape, it's very important to kind of study where are deals today. And so one of the things within that data set, as I've said to myself and my team, is we've got to look at more current data to see where are things as of today. And there's also certainly some more scale data in terms of being several years or multiple years having occurred in the past. And that has less relevance. And so, yeah, our goal would be to try to get maybe another 20 other deals, and then hopefully we can start to really kind of understand and apply them back to any course-based valuation we do in Mercer and Oliver County.
Move to admit exhibits 32 through 53, excluding exhibit 50.
Any objection?
I'll note our objection on relevance and foundation.
Objection is noted. The exhibits are admitted.
I'm going to just briefly switch gears here, Mr. Stockness, but in situations where maybe you don't have as robust a data set, are there other methodological approaches that you might take to conducting evaluation or appraisal of this nature?
Yeah. So what we're looking at here is a market comparison benchmark, and so we're looking at other market transactions of like-kind deals. And the more we can understand those deals and understand the research, and the more data we can have in terms of being able to really review it, it's certainly going to be helpful. But in any valuation like this, and in really any real estate valuation, is you're looking at all applicable valuation approaches. And here you have kind of the market-based approach, which I just discussed. And then the other approach that we really haven't even gotten into yet, but that we would certainly be taking a look at, is the income valuation. And what that is looking at what is the fair rate of return back to the real estate, in this case, core space storage, based on the anticipated kind of enterprise value of the larger business operation, and to try to figure out how do you determine a fair rate of return on the real estate for that use.
And would it be an accurate characterization to say that when you're looking at the income-based approach, ultimately what you would be considering is the proportionate share of the net revenues that should be going to the landowner based on their property interest in the facility?
That is correct.
Okay. No further questions?
I'm sorry, I don't know your name.
Mr. Examiner, my name is Ty Glutt. I am with Frederickson and Byron, appearing today on behalf of the applicants.
Okay, I should have given you an opportunity to appear. I apologize.
I think my appearance was noted by Mr. Bender on the first day.
Okay, great. Okay. You can proceed, Attorney Glut.
Thank you, Mr. Examiner. Good morning, Mr. Stockness.
Good morning.
Just a couple of quick questions. Based on my understanding of your testimony, you are not able to provide an opinion on what fair market value or what pore space in Mercer, Oliver, and Morton County, North Dakota is worth today. Is that correct?
That is correct.
Okay. In fact, you said you weren't able to provide a credible analysis at all today. Is that correct?
It is.
And are you aware that the commission who is reviewing these applications only has jurisdiction over a determination of equitable compensation for non-consenting owners, and they have no jurisdiction over the actual compensation paid to pore space owners?
Yes, I understand what you're saying.
Okay. I have no further questions.
Any questions from the staff? You can call your next witness. Oh, you
I
want to
just
redirect?
have one quick redirect for Mr. Stockness. Mr. Stockness, are you ready, willing, and able to complete the work on this appraisal assignment, given the time and data to do so?
Yes, if we're able to get the appropriate time, we are ready to do it.
No further questions.
Okay. Now you can call your next witness.
And hearing examiner, I apologize. I know we're just getting underway here, but we need to just get a couple of things set up for the next witness just to prepare. Could we just take like a couple minutes?
Sure.
Okay, thank you.
We'll go off the record. Okay, we're back on the record. Mr. Broughton, you can proceed.
Thank you, Your Honor. We call the Swenson Living Trust intervener by and through its trustee, Kurt Swenson.
Mr. Swenson, please raise your right hand. Do you solemnly swear or affirm under the penalties of perjury the testimony you're about to give in this matter will be true and correct to the best of your knowledge and belief?
I do.
Can you state your name and address, please?
Kurt Michael Swenson, 5774 21st Street Southwest, Beulah, North Dakota.
And do you live there with anyone?
I live there with my wife, Faye.
Okay. And can you give us some background on how this project affects you in a general way?
Sure. Yeah, we have lived where we live since 2008. We moved back to North Dakota then, where we wanted to have our kids grow up next to their grandma, Donna, and live on family farm. We wanted to enjoy our extremely valuable peace and quiet that we have out there. Unfortunately, the last 34 months has been anything but quiet in Oliver and Mercer counties due to the applicant's actions.
So what land do you own that is impacted by this project proposal?
We directly own or have an ownership interest in properties as a trustees for the Swenson Living Trust. It covers approximately 1,400 acres, and I believe there may be an exhibit that shows that.
We'll pull up, it's in the binders, exhibit LO81. All right, can you tell us what we're looking at on Exhibit 81?
Yeah, Exhibit 81 is a map showing the 3 disposal facility areas for the CO2. The colored boxes or shapes are land that we own or have ownership interest in that is being affected by the proceedings or this hearing process. I can walk through the descriptions quickly of what we have. We have the northwest quarter section 22, Tier 142 North, Range 87 West. We nicknamed that one Thomas's for the family that had lived there prior to my wife's family acquiring it. We have the southeast quarter of Section 15, Tier 142 North, Range 87 West. That was Faye's Uncle Ralph's, World War II vet. Section 21, Tier 142 North, Range 87 West, all of that section. That includes the original homestead. That is where our house is. That is where my mother-in-law Donna lives. That is where Faye was raised, and where her family has lived for over 110 years. Since moving back, we have worked to acquire other properties. The other properties would include the west half of the northeast quarter of Section 14, Tier 142 North, Range 88 West. That was from the Scheid family that we acquired that, and that is inside the BK Fisher disposal facility. We had the opportunity to purchase and acquire land from former Secretary of State Jim Kuzler's estate. Jim was affected by the poor space options and lease agreements. As he was dying, he asked us to make sure that we worked to advocate for landowners. And it's one of the reasons that I'm here today, to make sure that there was actually fair treatment to landowners in this process. So Section the southwest quarter of Section 9, Tier 142 North, Range 87 West. That's the windmill quarter where we have Indian rings and is just the most beautiful mule deer country you can see. We also have Outlot B, the east half of the northwest quarter, Section 7, Tier 142 North, Range 87 West. That's where Jim grew up. And my son now owns that house. That's on that property. And we have the southeast quarter, Section 27, 143, Range 88. That was Jim's uncle, Ace, that owned that. So in addition to those properties, we've recently signed a purchase agreement for more land interest in 14287 Section 20. We have options on another 480 acres in that area. All of that land is either inside one of the disposal facilities or in between the 3 disposal facilities that are proposed in this application being heard here today.
You had experience with renewable energy developers demanding the use of your land?
I have. We have. It seems like everybody wants what isn't theirs. They want our land. We've had relentless developers from wind industry wanting to put up their noisy light flickering, red lights flashing all night in our windows. The solar developers wanting to blanket our native grass prairies and crop fields with silicon derivatives. And now we have these CO2 disposal developers wanting unrestrained use, not only of our pore space, that is 1 to 2 miles below the surface, but of the surface lands itself. All of these examples use our taxpayer funds to develop our land for the Green New Deal agenda, the 30 by 30 land grab, albeit the latter is the only developer, unfortunately, that's trying to force their private, for-profit, out-of-state enterprise upon our private property without our consent. Other developers, they seem to respect us, and if we say no, they get the hell off our property. It's not that we're against the applicant or this project. While I do disagree with the use of taxpayer funds to reward their unconstitutional taking of private property, we simply want to be treated as an equal party in a private treaty that is negotiated between a willing seller and a willing buyer. The unconstitutional law in Century Code 3822 that allows the applicant to take our private property without our consent, making us a subservient party in a private treaty negotiation when the applicant holds the trump card of the heavy hand of government disguised as amalgamation. This private property taking does not allow our constitutionally guaranteed judicial hearing or a trial by a jury of our peers to determine just compensation if we can't arrive at that private treaty.
Have you had an opportunity to express any of your current concerns to the applicant?
We have, yes. We were initially contacted in August of 2021. I got a notification on our Ring doorbell on my phone, saw the video, didn't quite recognize him, but recognized him as one of our neighbors, Jason Erickson. He indicated that he'd like to talk, that we were going to be receiving a letter the next day. This is on a Sunday afternoon when I was running to put that corn planter away. And that they wanted to talk about a lease. And I said, well, I'm heading into town, but I'm driving a tractor, you'll have to catch me. So he caught me. And he explained what was coming in this letter. We received the letter the next day or two. Upon reviewing the letter, we invited Jeff Scarry, the applicant's counsel, to our farm and ranch, along with several of our neighbors, to learn more about their project, and to our knowledge, this turned out to be the applicant's first landowner meeting. This is before any community or landowner outreach had taken place. And at this meeting at our farm and ranch with our neighbors, we were provided the first hot off the press version of the lease. That was the applicant's offer to place an option on our land to lease the pore space for their CO2 disposal, allowing them the full use and access of our surface. As I stated, it takes a willing seller and a willing buyer to reach an agreement. Unless, in this case, the heavy hand of government, it can be used to take it from one and give to another. Our family wasn't a willing seller that day when the applicant approached us, but we did give them the courtesy of hosting with open arms their first landowner meeting at our farm and ranch. You see, we are in favor of development. We recognize that our state relies on industry to provide jobs and develop the resources that we have.
Do you
Yeah.
have, I'm sorry.
Well, I just wanted, on that, I just want to say, we're not against the project. We've never been against the project, but we simply don't agree with the terms and conditions. And that's still the case today as I sit here.
And do you have any experience yourself with the energy industry or ethanol industry or with CO2 capture and sequestration?
I do.
Can you tell us about that?
Sure. After completing, I went to NDSU, completed my engineering degree in 1991. In fact, probably crossed paths with Wade when he was there playing football. I went to work at an oil refinery in Minnesota. I was there for 12 years, fulfilled 11 roles while I was at that refinery. Much of my time was spent in the maintenance and operations of certain process units, one of which was a carbon dioxide production unit. We produced high purity CO2 for multiple markets, sold it. In my final role at my time at the refinery, I was responsible for the total health, safety, environmental performance, and operational reliability of these process units. At that refinery, I learned the characteristics and hazards of CO2. And while there are many hazards, the primary one applicable to the applicant's permit that deals with human health is the simple fact that CO2 is heavier than air. And it can displace life-sustaining oxygen. In high enough concentrations, it can displace enough oxygen that it will deprive the body and the brain the oxygen needed to live. I left the refinery in 2003. We moved our young family to South Dakota to join a startup ethanol business. While we were in South Dakota, I had the opportunity to be a plant manager at the world's largest dry grind ethanol plant that was under construction. As we grew the business, I was promoted to vice president of operations. I was over eventual 16 ethanol plants across the country, and we became the world's largest ethanol producer. Several of those plants that I had in my fleet at that time are now intending to send the CO2 into the proposed pipeline that the applicant has to North Dakota and bury it under our farm and ranch. And isn't that ironic? While in the ethanol industry, my responsibilities included safe, environmental, responsible, and compliant, efficient operations. I had corporate-wide responsibilities for the safety and health systems for over 1,500 people, including employees and contractors. I oversaw complex safety systems. Those safety systems included detailed process safety management, analysis of risk, injury, and incident analysis. I had an detailed understanding of our feedstocks, our chemicals, and our products, which included CO2. Carbon dioxide is a major product of the fermentation as yeast convert the various sugars in the ethanol production process to alcohol. Not unlike distilling moonshine, with approximately a third of the kernel of corn becomes CO2 by mass. And then the ethanol plants traditionally, for the most part, release that CO2 to the atmosphere after scrubbing the pollutants. And then that CO2 is available to be consumed the next year by the corn to start that cycle all over again. In a year's time, we would produce over 5 million tons of CO2. In my tenure, we had to solve many safety risks. It was an emerging industry. One of those specific risks was leaking pressure safety vacuum and relief valves on the fermentation processes, as an example. Our employees would need to physically be near or inside a cloud of carbon dioxide to perform maintenance work at times. Obviously, this required a lot of detailed planning, risk assessment, special purpose personnel protective equipment, and significant oversight. CO2 is nothing to mess around with. I've had to oversee incident analysis of employees who were overcome by CO2 and the vapors that displaced the life-sustaining oxygen that they needed to breathe. I'm professionally qualified through training and experience to understand the actual hazards of carbon dioxide. Carbon dioxide is nothing to be casual about. It is not the same as crude oil. It is not the same as natural gas, refined petroleum products, or other things that the regional media pundits around here would have you believe. Its unique properties make it uniquely hazardous. CO2 can be extremely dangerous, and permitting these disposal facilities should be done with the utmost respect for the specific hazards that CO2 brings and the specific design of the injection facilities at each of the injection sites. The specific topography, potential release point heights, the process data, weather conditions for each of the disposal facilities will need to be considered. So my other roles in my career have exposed me to detailed process plant design, process hazard analysis, level of protection analysis, safe design methodologies, which always consider requirements for safety systems to be incorporated into facility design, training, and operating procedures. We would also review the system for likely leak points, such as pump seals, flanges, and worst-case scenario breaches. A dispersion analysis may have been conducted, depending on what the scenario was, and based on a specific set of process, environmental, and topographic and weather conditions, we would get a wide range of results that we would evaluate on how those gases dispersed and how far out the concentrations that were dangerous to our employees or the public, in many cases, of those process gases may be realized at varying receptor points. Depending on the chemicals that were being released, these receptors could have been ignition sources, public roads or right-of-ways, neighboring homes, or other culturally or fauna important locations.
So outside of the experience that you just discussed regarding your education as well as the industrial processes and facilities management and the work with the hazardous chemicals, can you tell us if there's any other experience you have that you bring to bear upon your work related to this project and your protection of your property?
Sure, yes. In addition to my 30-plus years regarding process hazards, specifically some of that with carbon dioxide, I've also had 30 years of training and experience in contract negotiations, contract legal review, contract risk management strategies, including detailed insurance coverage analysis. Along with my practical contract experience, I've negotiated over hundreds of contracts. I've also had legal training from Cornell University on how to create effective contracts, how to interpret an effective contract, how to manage risk in contracts, and enforce those contract terms.
So you mentioned that you received some contract documents from the applicant at one point. What did you do with those contract documents after you received them?
So after we received those documents, they were the hot off the press version of the applicant's option and lease agreements. We reviewed them, of course. We shared them with Faye's family, who in many cases owns interest in the land that we do. And collectively, after seeing the one-sided nature that was in favor of the applicant, with very little protections for the landowner, I decided we should have it reviewed by attorneys. We consulted with multiple attorneys. Every one of them, 3 in fact, specifically recommended do not sign. Didn't get anybody to tell us to sign that document. So then it was decided that, you know what, we are in favor of the industry progressing in North Dakota, so what can we do as a family to help this move forward? So we attempted, or decided to attempt, to negotiate a contract that would give equal protections to landowners as much as it would allow the developer to do what they needed to do. You see, a good contract results when you get what you need, but maybe not everything you want, yet you find it acceptable to sign. Initially, we initially reviewed our feedback with the applicant on a virtual meeting during COVID. And we did that fairly quickly after receiving it. And only to be met in the closing of that meeting with a statement by Mr. Basons of, "Thank you for your criticisms of our agreement." Well, we didn't think they were criticisms. They were thinking we were expressing what we felt we needed to enter into a mutual agreement. Thereafter, we formed a group of landowners in the area that was being targeted by the applicant. We had a common goal of arriving at a contract that could be used as a model contract for the nascent North Dakota CO2 disposal industry. And after seriously hundreds of hours of landowner input and attorney input, which they don't give us for free, sorry, Derek, we invested in that red line of the applicant's initial agreement. And we provided that to the applicant on January 25th, 2022, which was a landowner version of the lease documents that we asked for their consideration of.
All right, we're gonna mark an exhibit here, but before I do that, a quick question, Mr. Swenson. Did you have, and I don't want you to talk about communications with attorneys, but did you hire legal counsel as well when you were developing a response to those contract terms?
We did.
And was I one of those attorneys?
You were.
And was there another attorney that was also involved in helping with that effort?
Charles Carvel.
Okay. All right, we are marking landowner exhibit 87. Johnny, hand me those. I'll start. Thank you. In your honor, I once again was remiss, but while we're paused here, I had discussed a map prior at exhibit LO 81, and I failed to move to admit, so I had moved to admit exhibit 81.
No objection.
The exhibit is admitted.
Mr. Swenson, we've now handed out exhibit LO 87. Is this a copy of some of the red lines that were generated to respond to the offer from the applicant?
Yes, it is.
Move to admit exhibit 87.
Any objection?
No objection.
The exhibit is admitted.
Mr. Swenson, can you tell us about what happened when you sent your counteroffer with your edits and suggestions back to the applicant? What happened next?
Yes. So we sent it to the applicant. Initially, as I normally do, we asked for just more of a, kind of business-to-business meeting, so I asked to have meetings with Mr. Basance. I invited him into my office conference room, and we had several meetings with him, ultimately, to try to help explain what we had changed it from the original document, why we had changed it, and to get a sense of what they might accept specifically or maybe in concept, and what they would not accept. Some of the meetings were one-on-one, some we had counsel present. I can tell you all of them, we got significant amount of lip service from the applicant's attorney. We took this process very seriously on the landowner side, expecting to get a red line version of the lease back from the applicant that would actually give us specific feedback to what they would take or what they would not take. And I can swear ultimately, as of today, we've waited 870 days since submitting the landowner lease versions, and we're still waiting for a contract red line to be returned. And if they have one here today, I'd be glad to accept it and review it. Through this process of learning about the CO2 disposal technology and regulations and legal theories behind this and dedicating hundreds of hours each year, I routinely field calls from landowners across the country who have similar issues due to the lack of state regulations that provide protections for the landowner. I felt it was necessary to get involved in the bigger picture of CO2 disposal. As a result, I have, right here in this room, met with Mr. Helms in his role as North Dakota's Oil and Gas and Department of Mineral Resources, where he informed me that I was being faced with the state's perceived police powers over our property. I was informed by Mr. Helms, and he acknowledged a lack of landowner protections in administrative code, including safe setback distances from public receptors. I met with the industry leadership in ag, coal, and gas industries in all of the representative organizations to learn their views on this new disposal industry coming to North Dakota. We hosted numerous landowner meetings in Oliver and Mercer counties, along with meetings in Hebron and Glen Ellyn. I presented at the Northwest Landowners Association annual meeting, provided multiple presentations to state and county level North Dakota Farm Bureau meetings. My expertise and assistance on the topic were requested by a group of landowners between New Salem and Glen Ellyn when Morton County was illegally trying to push a special use permit through for another CO2 developer, which included a direct air capture facility. I've written letters to the editor, co-authored articles for publication, and have been interviewed on various TV programs, radio shows. I've advocated for legislative changes in the most recent 2023 session, unfortunately learning that most of our legislators, they're under the spell of Mr. Helms, and the industry proponents have forgotten about the citizens whom they represent that are adversely affected by unconstitutional elements in our current century code. All of this effort has been done with a genuine overarching goal, advocating for regulatory change while educating landowners on this emerging CO2 disposal industry in order to protect not just my land and phase land, but all landowners. Hopefully, this has resulted in some improvements for the landowner's ability to negotiate with these well-funded developers that resulted for them contract language that they felt was fair to both parties.
So with all that experience, did you also then engage with the applicant on a negotiation or attempt to work on the suggestions for the contract documents with them?
Yes, I did. I previously stated, we had, taken hundreds of landowner and attorney hours in that red line to conform their agreement to something that we felt, well, I believe any North Dakota landowner would consider signing unless they were simply opposed to the applicant or their project. Much of the reclamation and restoration clauses were spearheaded by Mike Haupt, who was a former Department of Trust lands employee and generally is based on North Dakota trust land documents. If you look at our red line, what you're going to see is it's mostly red or purple in the one that was handed out. So their contract was so poor that it really should have been flushed down the toilet and started new. But to aid in our discussions with the applicant, we narrowed the list down to some major topics.
And what were the primary points of concern or those topics that you just referenced?
It really started out for us with, what are you wanting to put under our property? What is it? The original versions of the lease were very loose on the definitions. It could have been 50% carbon dioxide, 50% hydrogen sulfide, because it allowed incidental substances or other substances. So we added a definition, a simple one. We put a percentage in of what the purity of the CO2 should be, so that we knew, based on our knowledge, what the hazards would be of what they were putting under our property. We focused on, well, what are you actually leasing? Because the lease was, we want to lease everything under your surface and more when we'll get to that. This conference room probably talks more than any other conference room in the world about different subsurface stratum, different shale plays, different levels within the shale plays, such as the Three Forks, or the Madison, or the Buchan, or whatever they are. And the applicant wanted everything. And we thought, it's really only fair, and it's pretty standard in oil and gas that, you should just tell us exactly what you want, and, we'll agree to that. But no, they wanted everything, so we said, no, you're going to give us a single geological formation, and if that works out for you and you want to lease something else like an oil and gas lease, you can give us a new lease for that. And so that's what we did. They also had these warranties, reps, guarantees, things like that. Well, if you're not familiar with contract language, you may not know the importance of those, but those are very important in a contract if you're signing for that.
Can I pause you real quick, Mr. Swenson, though, and ask, so a title warranty clause was contained in Summit's contract, which they agreed yesterday they need to remove, but they weren't willing to remove that for you during the negotiation?
I think it was on Tuesday, Derek, that they agreed to remove it, but yeah, they wouldn't remove it.
Okay, what are the other topics that you attempted to address with them that they wouldn't?
Well, in the option, it included geophysical exploration activities. So as you know, that involves seismograph trucks and maybe some exploration in other ways. My mother-in-law, Donna, had a water well that her cattle relied on, damaged by an earlier, albeit a little older technology seismograph process that came through. And that private property water well never produced water again for her cattle. And she was never compensated for that. So we asked for some setbacks in excess of what the state rules that they were claiming applied to this gave us. And we felt that that was fair to make sure that she was comfortable. We asked that in case you damage our water springs that provide life-sustaining water for the cattle, or you damage our wells, you're going to do some testing. You're going to test the quality and the quantity of our water, whatever sources there are that we use and rely on before you do it, and you're going to do it afterwards, and you're going to be accountable. They asked us to indemnify them, and if you're not familiar with indemnifications, but it means that we will defend them and protect them and hold them harmless for actions. Well, we thought it was only fair that they defend us and protect us and hold us harmless as well. So we asked for that. What was interesting to me, and Mike helped especially, was the lease gave the applicant unrestricted, full use of our surface, unrestricted full access to our surface lands. And they could put anything they wanted, wherever they wanted on our land. If you signed the document that they put in front of us, and many of our neighbors did, unfortunately. So, because of that, Mike's experience said, you know what? We're not necessarily opposed to things being on our land at that point, if we can have some control, but we'd at least like you to have restoration requirements in your documents so that we know that if you're forcing something onto our land, that we know that our land is going to be restored and reclaimed after you leave. So we added those, and that makes up a large part of those document red lines. One of the concerns that we had was that this was a newer company, unproven in North Dakota. We didn't know them before my Ring doorbell went off that day in August of 2021. So we had no idea what their funding was. Are they going to follow through on their commitments? And so we asked for bonds. We asked for, if you're going to bring people onto our land and have them do geophysical exploration survey activities, build a compression station outside my bedroom window, or whatever it is that you're doing, I want to make sure that you pay them so they don't put a lien on my property. They didn't have that requirement, and so we added that you will have a payment bond to pay your suppliers and your service providers. In addition, we asked for bonds for restoration. Because, as we've seen exhibited in this room in hearings, the state doesn't stand for landowner rights. The state stands for industry, and they don't make them reclaim wells and plug old abandoned wells where companies have gone broke and left, because they don't have a proper bonding program. So we asked for a bond. If you're going to put shit on our land, you're going to take it off our land eventually, and there's going to be a financial instrument that ensures we have that covered if you go broke or when you sell and flip your company to some foreign country. I was flabbergasted that they wanted to come onto our land in the option phase without insurance. The option had no insurance requirements for them to drive a major truck on our land, put a bunch of stuff on our surface, have people that we have no idea if they have employer's liability insurance or general liability insurance or pollution insurance for the antifreeze that leaked all over the state trust land that we rent. So we added insurance requirements. We added a significant amount of language that if they wanted to put something on our property, again, evidenced by the fact that we put it into the document, that if they wanted to put something on our property, we were going to have some control, but they were going to have, we were going to know ahead of time what that form of easement was. There was no form of easement included that we would understand what the terms and conditions would be to evaluate, with their absolute right to put whatever they want, wherever they want on our land. So we added an easement structure. because they wanted to use our surface, as I mentioned in my opening statement, we have very valuable peace and quiet on our farm and ranch. I was greeted by antelope last night when I left here driving into our farm. I was greeted by mule deer and pheasants, and when I got out of my diesel truck, shut it off so I could hear, you know what I heard? I heard doves cooing. I heard the pheasants crowing and greeting me when I came home. When I woke up this morning, I had 2 buck mule deer, one eating off the apple tree in our backyard and one eating off a Caraganis tree, having browse for their breakfast. Because of that, we wanted to have some restrictions on what they could do on our lands and where. So we defined some simple requirements that we would have to give some form of consent, and we wouldn't necessarily unreasonably withhold that. But you know what? You don't get to have lights shining in our bedroom window with your pump station. We don't want that. I like to see the stars. I like to see the northern lights out our north-facing bedroom. I like to see the Milky Way when I'm in my hot tub sitting on our south patio. I don't want your lights shining in me. I already have hundreds of those damn red lights flashing to the south of us from those wind developers. I was also very concerned about noise. I'm sure you're all familiar with Williston and Williams County lawsuit going on right now with the data center. I don't want to listen to a compressor station or a pumping station injecting CO2 when I'm sipping my coffee on my deck in the mornings. I don't need that. I don't have it today, and I don't want it in the future, so we added some noise requirements. In addition, we asked, because you're going to be paying us based on your injected tons of carbon dioxide and other substances, we want the right to audit your books. That's a standard clause. When you're being compensated based on their records, we want to be able to audit it. And as I'm sure they'll tell you, we asked for some financial changes in the structure of the lease document, which you have in front of you. We felt our land and the use of our land was worth more than they were offering. We had started to do research and develop data points on what our land was worth at that time, or our pore space and the use of our surface. In fact, we developed a schedule of consideration. A schedule of consideration that would say, if you're going ahead of time, we will know what you're going to pay us if you put a pipeline on our land. We're not going to sign this agreement like you're asking us to do and then negotiate when you have the absolute right to put it on. We're going to negotiate the price of this up front. I'm not going to sign a contract and then be held hostage by you. So we added a consideration of values for per rod of pipeline based on its size, per linear foot of communication cabling or devices, per communication towers, and all other surface facilities that at least we could imagine, such as roads and surface acres set aside for pumping stations and things like that. So we included that as well. And, you know, we didn't know what to think initially when we saw the 25-cent royalty based on their lease agreement, their option and lease agreement for the injected tons. And where I went is I said, well, how much is this project going to make for you, and what are your economics and what are your costs? And I sat in numerous presentations that ultimately happened, and Mr. Basons presented even one time at the Oliver County, I think it was a commission meeting, and shared their economics of what the uplift of the ethanol plants and their revenue sharing agreements would bring them, 29 to 30 cents a gallon was what would be split between the developer and the applicant here, or the ethanol plant and the applicant. We saw that, we obviously understood the 45Q tax credits, and we researched significantly California or the West Coast Low Carbon Fuel Standard credit market, which I'm sure many of you know has tanked significantly since the time that this started. And in all of that, we really felt that you're leasing a resource of ours. You're leasing pore space that's ours to develop. Not unlike an oil and gas in some manners. We felt, well, why don't you pay us a royalty then based off your profits, your net profits, such as an oil and gas lease would. So we proposed a 3/16 royalty on net profit. So those were the major lease changes. Obviously, there's a lot of nits and gnats in there as well, as you'll see as you walk through that document. I previously mentioned that I have not received a formal return red line as is customary in contract negotiations. Waiting on today 870 days, and I'm still counting. I'll acknowledge that the applicant has made some changes in their agreements with landowners based on our feedback, and I'm glad for that. I'm glad that landowners have been made improvements from that first lease version that should have just been ripped up, burned, flushed down the toilet, taken up to the burning barrel at Donna's, and just never saw it again.
So the red lines that were sent back, you'd indicated that both myself and Charles Carvel had worked on them, in addition to you and Mike Haupt. Are you aware of who the attorney was on the task force that helped draft the Class 6 regulations for North Dakota?
I am.
And who is that?
Charles Carvel.
Okay. Are you familiar with the policy statements in law related to carbon sequestration in North Dakota?
I almost have them memorized.
And you're fairly familiar with the project at this point, obviously.
Yes.
And so I want to talk about
Attorney
some of the
Broughton,
recital.
Attorney Broughton, let's just take a 10-minute break right now.
Okay, sounds great.
We're off the record. We are back on the record. Attorney Broughton, you can continue.
Thank you, Your Honor. Mr. Swenson, I was asking about the policy statements in the Class 6 statute, and just to direct your attention at the policy statement in 3822 notes. It is in the public interest to promote the geologic storage of carbon dioxide. Doing so will benefit the state and the global environment by reducing greenhouse gas emissions. Doing so will help ensure the viability of the state's coal and power industries to the economic benefit of North Dakota and its citizens. Further, geologic storage of carbon dioxide, a potentially valuable commodity, may allow for its ready availability if needed for commercial, industrial, or other uses, including enhanced recovery of oil, gas, and other minerals. Do you feel the applicant would accomplish any of these policy goals with the project proposed for your land?
I do not.
And why not?
Well, the first one is the whole kind of public interest piece. It's a pretty simple one. Their projects or their permits requested fail on that merit of that policy statement. You know, the legislature puts that in the policy to give cover to their unconstitutional practices of taking our private property without constitutionally mandated due process. The applicant has not just demonstrated with evidence on the record that their project meets the threshold of being in the public interest. They have told publicly that it will create jobs, and I'm sure it will. It will have economic benefits. Economic health will improve because of it, and I agree. And they will have increased tax revenues because of their project for the state and local jurisdictions. Unfortunately, these are all constitutionally barred by North Dakota's Constitution when you consider a physical taking of our private property. The only constitutionally allowed physical taking by a private company for a public interest is if they're a public utility or a common carrier. They're neither. They're not a regulated public utility in the disposal facility, and they're not a common carrier in the disposal facility. They've stated their pipeline intends to be regulated as a common carrier, and this has no bearing on the pore space. Common carrier regulations are under the purview of the Public Service Commission, not the Industrial Commission. The PSC regulated pipeline ends at a terminus red dot that we discussed in this hearing, miles away from the disposal facility. And those regulations cannot be applied under the Industrial Commission authorities. Additionally, the applicant has set up a maze of various LLCs and such. They're just simply a separate company from the pipeline.
What about the other policy statements?
Well, let's talk about the environment. That we're going to benefit the global environment by reducing greenhouse gas emissions. I can affirmatively state that the applicant has provided no data or evidence or proof on the record in these hearings that the project will meet this policy statement. Mr. Bason's even testified that it will not change global temperature. Further, as a direct result of the applicant's request for amalgamation, which results in a physical per se taking of our private property, this goes in direct conflict with common law that was handed down in 1976 in the North Dakota Supreme Court case Square Butte v. Hilken. And that opinion confirmed that in a physical taking, the applicant must meet the threshold of a substantial and a direct benefit to the public. Well, who's the public? It's a North Dakota citizen. There's clearly no substantial and direct global environmental benefit provided to North Dakota citizens by the applicant's proposed energy-intensive capture, transport, and disposal of carbon dioxide as they testified to. To meet this policy objective, the applicant should be required to demonstrate by the Industrial Commission to submit a complete carbon dioxide mass balance. That mass balance should include not only the carbon dioxide produced by the energy they use to capture, clean, transport, and dispose of the CO2, but all of their other operations produced by their employee vehicles used to work, office heating and cooling, the steel manufacturing for their pipelines, the transport, the compressors, the buildings, all of the manufactured items that go into it should be included in that CO2 mass balance if you want to prove and find that it's in the public interest on this policy statement. In addition, they really ought to include all the hot air they expel in the CO2 with that too.
What about the state's coal and power industries and economic benefits in that regard?
Well, I don't see them tied into a coal power plant with a pipeline, or any power plant for that matter, coal or otherwise. They publicly claim that the carbon dioxide will be disposing of 57 ethanol plants in our area and surrounding our farm and ranch, 56 of which are from out of state. In fact, if you will hear, and you may have heard recent statements by Jason Bohr, the head of the Lignite Energy Council, that, that is North Dakota's leading coal and power industry representative group, a firm, they have no association with this project. So I don't see how it's benefiting them.
And based on both your experience as well as your negotiations with Summit, do you have an understanding as to whether they will have a ready availability if needed for commercial, industrial, or other uses with respect to the CO2 they're putting downhole?
So I can rely only on what I have heard from others or have researched. I can tell you that John Haryu of the EERC and other employees, Wes Peck is a good example. Wes's daughter went to college with was one of my son's best friends in college. That it's not economically feasible to recover this carbon dioxide from these geological disposal facilities. And Mr. Haryu even states specifically that there has been very little work done on trying to recover CO2 from injected masses.
And did Mr. Haryu state that at some point in any kind of public forum?
Any effort being made towards
Sorry? Yes, he did.
And in what forum did he make that statement?
It was in a presentation to the joint, I lost the video here, or thing. It was in a presentation to the joint Senate and House Energy and Natural Resources Committee. We're having technical difficulties here. There you go. I'll play it here.
is there any effort being made towards recoverable storage?
Sure. There's really been Representative Twite, members of the committee. There's been very little work done on trying to recover CO2 from injected masses. So, in essence, when injecting into something like our Broom Creek Formation, you're injecting into an already water-saturated zone. And so our expectation would be very, very little ability to recover that CO2.
So I have to rely on others, and I would view that in that presentation that Mr. Haryu is an expert on that, and that I don't think that it will be available for enhanced oil recovery, and they're not going to pump it out of my land once they put it in. It'll be there forever. you know, even if it were economically feasible for them to do that, the applicant would end up having to refund a portion of their 45Q tax credits. They'd lose their revenue sharing along with their customer of any low carbon fuel standard credit pricing uplift they obtain because, well, the ethanol producers, for the ethanol producers, that LCFS credit requires permanence, as Mr. Basance testified to in this hearing. And it's in my opinion that the applicant's statement or lack of evidence on this record for this hearing do not meet that public interest threshold.
As someone who pays state and federal taxes, what's your opinion on the use of your taxpayer funds to promote and fund the applicant's project?
So I think we've affirmed that the weight of the evidence in this hearing shows that the project is not meeting North Dakota's policy objectives. So why are they pursuing this project? The simple answer is to take part in a massive wealth transfer scheme, taking taxpayer dollars, or maybe we should say debt of our grandchildren, for those of you that may have grandchildren someday, and putting it into their out-of-state silk-lined pockets. All through North Dakota's complicit regulations that the applicant has not met the burden of proof for their projects to be approved. So in addition to these 45Q tax credits that are provided to the applicant's investors or financiers at the reported project capacity of 18 million metric tons per year, which has been raised obviously since initially we met with them, puts $1.5 billion in their foreign silk-lined pockets of our money and future federal debt obligations. North Dakota, unfortunately, is, you know, they're contributing a bunch of dollars to this as well. You may have heard about the recent $300,000 grant awarded for a carbon dioxide re-education campaign, putting more tax money into the silk-lined pockets of local media pundits and engineering companies that suck at the teat of our government. Our taxpayer monies would have been better spent putting up billboards stating North Dakota is open for CO2 disposal. Don't worry, our citizens are too stupid to understand it. At least that would have provided jobs. Changing the billboards out, we would have had people employed with that new signage going up. They would have put fuel in their trucks and their equipment, bought some candy at the gas station, driving our economy. And they probably would have had the signs made in North Dakota creating jobs. I'd like that one a lot better. In addition to the deployment of state-funded EERC program supporting the development of this applicant's application, the legislature provides for a payment in lieu of taxes to the counties for more taxpayer dollars, so the applicant doesn't have to pay property taxes for 10 years on their pipeline infrastructure. You can count the governor flying down to Iowa to meet with Rassetter or whoever he did, the EERC employees driving to Beulah for the public information meetings, and so on and so on. It sickens me that we have bought into this Green New Deal agenda in North Dakota, and we're now funding it with our taxpayer dollars. I'm sick of it. You should be ashamed.
Will you allow your land to be amalgamated by the Industrial Commission?
I can tell you right now, the state can try and take it. You're going to end up taking it from my cold, dead hands. And you're going to see how that works out for you. The state knows good and well that the amalgamation provision in Century Code does not meet the requirements of North Dakota's Constitution. North Dakota private property owners are afforded the due process method of eminent domain in our Constitution when the government allows a physical taking. The state knows that amalgamation is a physical taking, not a regulatory taking, as they sometimes say, by allowing CO2 to physically invade our private property of pore space. The state knows in the lawsuit they lost at the North Dakota Supreme Court against the appellant, Northwest Landowners Association, these injection of fluids into pore space is a physical taking. It's not a regulatory taking. They lost. The court The 5 justices of the Supreme Court of North Dakota affirmed that. The state knows that in the U.S. Supreme Court decision on Cedar Point, that even a temporary physical invasion of private property is a physical taking. It's not a regulatory taking. The state knows that allowing physical property such as pressure to migrate outside of CO2 disposal facility is the same as a physical taking. And even that pressure, it might dissipate over centuries. I don't know. They couldn't tell us yesterday in testimony that the current and future landowners' ability to use their pore space is damaged, as testified here by the applicant. The state knows they are not requiring the applicant to provide any compensation for this transfer of pressure or CO2 outside the bounds of the disposal facility, leading to a taking without any compensation. The state is trying with a lot of effort, while looking like a great contortionist, to convince a judge that while the pore space is private property of the surface owner, it doesn't deserve the same protection as surface lands, and their police powers get to rule the day for pore space. Yet despite all this great knowledge held at the state on these issues, I believe their arrogance in the application of unconstitutional law is resulting in the closest thing I've seen in my lifetime to a tyrannical government. It's high time they're checked on this by the citizens with all of our God-given constitutional rights.
Do you believe that equitable compensation, as that has been defined by Mr. Helms and the Industrial Commission, is acceptable?
Honestly, I don't know how they've defined it, but absolutely not. I'll disagree, I'm sure, based on what I've seen in the past. You know, it's common knowledge that when the state does a physical taking of private property, we as a property owner are granted certain due process in the form of an eminent domain hearing in front of a judge. With the state or their proxy, they have to substantiate that it is in the public interest and there is a necessity for the taking. And if agreed to by the judge, well, that property owner is then granted an option if they want a jury trial to determine just compensation. That's mandated by the Constitution. Here, in this sham of due process, we are not being given an impartial judicial hearing. As I mentioned earlier, the Oil and Gas Division is charged with both a regulatory and a promotional nature of their efforts. How can this possibly be impartial when they're charged with industry promotion? A judge is impartial as they are not tied to industry results. The property owner is once again in a subservient position to the applicant in determination of what should be just compensation. But it gets even better because the unconstitutional law states that the commission doesn't even have to meet the constitutional bar of that just compensation that a jury of my peers would determine. They simply determine what's equitable. Unfortunately for that property owner, there is no definition in statute of what equitable means, and it's up to interpretation of this room. And clearly, we have heard testimony from the applicant that landowners are not being equitably compensated. They're not. In fact, in an open records request from February 14th of 2023, the state has put on record that they do not have any records that would be used to determine how non-compensating landowners are or will be equitably compensated as required by statute for the Minnesota Power, Project Tundra, and Red Trail Energy carbon sequestration projects under 38220814. If the state has a burden of proof to determine that non-consenting pore space owners are or will be equitably compensated as a requirement of this century code, wouldn't you think they'd have records of how they did that? How did you determine? And how did they meet that statutory requirement?
We're going to hand out Exhibit LO 88. Mr. Swenson, we've handed out Exhibit LO 88. Can you walk us through what we are looking at in this exhibit?
I can. The first page of the exhibit is a letter written by Mike Haupt, February 9th, 2023, to the Public Information Officer requesting to an inspector obtain copies of public records, which is an open records request of how non-consenting pore space owners are or will be equitably compensated for the Minn Kota Power, Project Tundra, and Red Trail Energy carbon sequestration projects under 38220814. So that's the first page. Now, the second page is internal to the DMR, sent to a group that we're not sure who the actual recipients are. Please see below the open records request. If there are any questions, let me know. And the action requested was, if less than 1 hour of time, please place documents here, and they gave a internal file shared description of where to put them. If more than that time, please let me know of an estimate by end of day Monday, February 13th. The third page is the response that Mr. Haupt got, which is actually dated February 14th, 2023. So prompt response, thank you for that. It says, the records, the box is checked. The records you requested cannot be provided because no such records exist. Or the records are not records of this agency. And then it was typed in there, all negotiations for compensation were private conversations with pore space owners. So how did you figure that one out? How did you figure that the landowners would be equitably compensated if you have no records?
Move to admit Exhibit 88.
Objections?
No objection.
The exhibit is admitted.
So, Mr. Swenson, do you have concerns about how the compensation is being determined in these proceedings by the commission, if it is?
I do. You know, as it relates to this hearing, and again, just to be on the record again, we have been severely prejudiced by the state's lack of enforcement of North Dakota rules of civil procedure that are required in a hearing of this matter. We have been denied the opportunity to depose. I'm not going to dispose of you, Jeff. Okay. To depose or receive any discovery in this matter. None. Not one thing, not one deposition, not one piece of discovery given to us. Zero. That's zilch, nada. Setting aside this lack of due process by the state, the real matter is here, what is equitable? Since the state doesn't define it and it's not a constitutional term, I don't know what it means. Who really knows? Now, Mr. Helms will tell you that equitable and just compensation are pretty much the same thing. Just as he did on Friday, January 13th, 2023, in a presentation to a joint meeting of the North Dakota House and Senate Energy and Natural Resources Committee. Mr. Helms states, if there is just or equitable compensation, it's not a taking. And in the absence of that, it is. You know that's wrong. Of course it's still a taking. Just because somebody gets compensation, it's still a taking.
Can you play that video for us where Mr. Helms made that statement?
I'll find it here, yeah.
My conclusion and my attorney's conclusion is that if there is just or equitable compensation, it is not a taking. In the absence of that, it is. But if there is just or equitable compensation, it is not a taking. That would.
What's your response to that, Mr. Swenson?
Just compensation is required by and only granted in a taking. Mr. Helms knows this. That's a lie, what he did, or a misleading statement or you're just incompetent as the director of this agency. I'm not sure which it is. Furthermore, you admit that you don't know what the value is, just that everybody gets paid the same. How can you possibly not consider pore space value under this pretend, undefined by statute, made-up term of equitable compensation that you state you have no records of in this agency on how you evaluate if equitable compensation is being paid?
Well, how do you feel about the compensation being offered by the applicant and proposed by the applicant?
In an agreement, there's usually an exchange of compensation. The compensation normally gets determined by mutual negotiation. In this case of the applicant, there was zero negotiation on compensation. One that Mr. Basance testified to was originally set on the value of frickin' coal leases, of all things, and had nothing to do with the actual value of my pore space. Their approach has been take it or leave it. But we'll take your pore space through this frickin' amalgamation clause if you don't take our offer.
Okay, I'm going to ask you to refrain from swearing, please.
You left the rules of civil procedure when you slow-rolled
All
our
I'm asking is you don't
thing.
use the word frickin'.
What was the amount that the applicant was offering in that initial agreement?
25 cents per ton disposed of under our native grass prairies. And then when the Inflation Reduction Act was passed by the federal government, giving them more of our federal tax dollars and federal debt for our grandchildren to pay, they gave us an extra 25 cents, making it 50 cents per metric ton for the landowner, a whopping 0.7% of their increase of $35 that they got for no additional costs on their part. Is that equitable or just? I don't think so. In a meeting with the applicant's North Dakota leadership team, it was stated by Mr. Basance, well, he didn't have any market data that showed they should pay more. And while market data may be difficult to obtain or ascertain in this nascent industry, we did provide them examples. We had found them, I'm not sure why they couldn't, on leases that were paying on different terms, all higher than the applicant. So we received no counteroffer to our red line of their agreement in which we had proposed paying the landowner similar to how this agency normally sees things paid on a royalty model based on a share of net profits, to which Mr. Basance termed this method untenable. It was untenable. I guess he won't have a career in oil and gas. But there are lease examples available.
Can you,
Oh, go ahead.
well, I was just going to ask you if you can give us a couple examples of
So
available transactions you just mentioned.
Dakota Gasification Company, just north of Beulah, is offering $1.70 per metric ton, 3.4 times higher than the applicant.
Can I have you take a look at Exhibit LO53? Sorry, that's in the binder, everyone. All right, looking at Exhibit 53, this has been previously marked. Is that the lease you referenced with respect to the Dakota Gasification?
It is.
Okay. And other than the Dakota gasification at the $1.70 per metric ton, 3.4 times higher than the applicants, any other agreements that you think are more appropriate compensation?
Publicly available, the state of Louisiana entered into an agreement with Air Products Blue Energy LLC, which shows royalty payments of $1.50 a ton, while the 45Q was at $50 per metric ton. But it also included an escalation clause because they thought that value might go up, that the partner or their other party on that agreement might receive. And in that case, that escalation clause included a 9% escalator of any increases above $50. At 9% versus Summit's measly 0.7% that they offered us for no extra cost to them. So when the $50 per metric ton 45Q payment went to $85, presumably with that 9% escalator, that increased payment would be $4.65 per metric ton, 9.3 times higher than the applicant's offer.
And is that agreement that you were just referencing contained in the record at Exhibit LO45?
It is.
Any other agreements you think are a more appropriate context for considering the compensation here?
The Permanent School Fund of the state of Texas entered into a transportation and storage lease in April 2022 with Bayou Bend CCS LLC. This lease was structured much more like what we had been proposing as landowners. In this case, they took it as a form of a percentage of facility proceeds, which ranged between 3 and 6%, versus our net profit 3/16 offer that we had provided them. In their case, facility proceeds were defined to include any consideration paid or delivered to the lessee, meaning the person that's injecting, including the value of the carbon credits on a cash paid basis or after-tax valuation. Very similar to what we had proposed, just that they had a lower number on gross and we had a bigger number on net.
And is the lease you were just talking about and referencing Exhibit LO43 in the record?
It is.
And so what do these three agreements tell you about the compensation?
Well, I am disheartened that this hearing is considering forcing our private property into a lease that is undervalued by
Mr.
national standards.
Mr.
because-
Examiner, I'm going to make an objection at this point on relevance. We're discussing compensation in leases that have nothing to do with this project and over which the commission has no jurisdiction. Second, this is all being done to making a constitutional argument before this commission over which they have no jurisdiction.
The objection is noted. I'm going to allow him to continue.
And I'll restate that. Why should we as landowners be subjected to a lease that is undervalued by national standards? Simply because that's what the applicant offered, without any negotiation on their part. Do we not have the right to advocate for the best financial result for the use of our private property? I sure think we do, but not here, not in North Dakota apparently. Somehow that law got, that right got lost. So they've demonstrated through the evidence of this hearing that they are not certain how far this plume of CO2 even extends under the lines they drew on the map that show an arbitrary concentration cutoff level of 5% carbon dioxide in the aquifer. They admitted on the record that carbon dioxide will extend beyond this line, and they're not able to attest on the record to how far carbon dioxide will extend beyond that arbitrary 5% line. They've admitted that it will go out there and eventually may invade neighboring properties that may or may not be leased. But in neither case, they're not going to compensate them. So how can the state possibly know if the pore space owners are being compensated equitably by statute when they don't know how far the CO2 will actually extend onto neighboring properties, and which pore space owners actually should receive compensation for disposal of their CO2 in their pore space. But there is no plan or commitment by the applicant to pay them, as testified to yesterday by Mr. Basons. How can this oil and gas division let us as landowners even evaluate the accuracy, the sensitivities, or the completeness of the applicant's application when they didn't even ask for or receive the seismograph data as was testified to yesterday? And nor did we.
And do you have property that is not located within the areas of review, but is still being impacted by this proposed project?
We do.
And can you explain that?
So the state is playing fast and loose with their inconsistent application of intervener rights by stating in your order, Mr. Gardner, to our trust that the commission will not consider the trust position insofar as it fails or it falls outside the consideration of Summit Carbon Storage Number 2. Much of our land was intentionally skipped over by the applicant, surrounding these lands of ours with injection wells. Due to the applicant's simultaneous injection plans in these 6 wells, their models predict that much of our property, as we saw on the record, will see an increase in pressure gradient of 800 to 900 pounds over the ambient conditions of today after their 20 years of injection, rendering our pore space unable to realize the same net present value cash flow for any commercial use that we engage in, and possibly risking our ability to monetize the 45Q tax credits, as was testified to by the applicant, as our rates of injection will be reduced to the applicant's pressure, by the applicant's trespass of their pressure onto our property, ultimately reducing the volume of CO2 we could inject in limited 12 years for the 45Q tax credits.
Can we have everyone look at Exhibit LO63, and Mr. Swenson, can you explain to us on this map if this illustrates in any way what you're discussing now? Yeah, yeah.
As you'll see, these are the 3 disposal facility areas proposed by the applicant. The upper left one being the BK Fisher well. The green border around that well is the current boundary being proposed for the disposal facility. The orange surrounding that is the area of review. The right well is the J.K. Hintz well, again surrounded by a green line for the border of their proposed disposal facility. And then the somewhat orange, I'm not sure what color that is, around that is the area of review. And then the bottom center well is a TB line gang well. The blue line is the proposed border by the applicant of the storage disposal facility, and the purple is the surrounding area of review. You'll see all of the intervener lands marked on there in colored blocks. You will see the white ones, which are specific to our trust, fall in between a lot of the storage disposal facility boundaries and areas of review even, but the boundaries are what's important. And overlaid on this map is the pressure gradient that the EERC through the applicant has provided of what the pressures will be after 20 years of injection by those 3 wells at their planned rates. And what you'll see is much of our land will have pressure trespass in our pore space, rendering it unable to realize what we could realize today for a net cash flow. But yet, We're not being paid. But our pore space is being damaged.
Move to admit Exhibit 63.
Any objections?
Yes, Mr. Examiner, Foundation, we don't know who produced this map, how it was produced. If the witness is able to give us a little bit more foundation in those respects, we may be able to remove our objection.
Mr. Broughton?
Do you have an understanding of the program in which this map was created, Mr. Swenson?
The Google Earth program?
Correct.
I do.
Is it your understanding that the images of the pressure maps produced by the applicant, as well as the boundaries produced by the applicant, are on this map alongside of the properties that are owned by the other interveners?
Yes, it is.
And all of those images are then compiled onto a KMZ file within Google Earth that then produces the map that we're looking at Exhibit 63.
It does.
Move to admit.
Any objection?
No objection.
The exhibit will be admitted.
We're going to take a look now at Exhibit 86. Is that one? That one, and this is the one that we emailed around to everyone, and I gave a flash drive to Judge Garner and to Mr. Bender. And Mr. Swenson, can you tell us what we're looking at on Exhibit 86?
This map is I'll call it a snip, but a copy taken from Minn Kota Power's, I guess, their process of the documents that they submitted and then were ultimately replied on and stuff in their petition to intervene in this hearing. I added myself the red line and the letterings or words that are called Swenson Trust Land and Minn Kota Power Well.
And what was your intent with creating this map, and what were you trying to illustrate here?
So as I previously mentioned, we were denied our petition to intervene on lands that we didn't have an interest in. And for some reason, for the same reason of that potential increased pressure, on their case of only 200 to 300, but in our case 800 to 900 in their leased pore space, Minn Kota was granted their petition to intervene in all three of these disposal facilities of the applicant. But yet we only get one, and we're affected by them way more than they are. How is this remotely fair? Once again, in this example of the state favoring the industry over the citizen.
Move to admit Exhibit 86.
No objection.
The exhibit is admitted.
You know, one can I can only get one conclusion from this, I believe, that the state is either trying to lay down some evidence in this action by evaluating correlative rights to prop up their unsubstantiated defense in an ongoing lawsuit with the Northwest Landowners Association, or they're just simply prejudicing us in this hearing with more lack of due process in this hearing by denying our ability to intervene on damaging our private property due to the pressurization of pore space while allowing Minn Kota to intervene. Which is it? Unfortunately, as the state has refused to enforce North Dakota's rules of civil procedure, we as a petitioner have not been given our discovery requests. We have not been able to depose anybody that would have allowed us to substantiate or refute the above claimed pressure gradient data by the applicant and impact by the applicant's uncompensated use of our pore space. as well, we have heard even more testimony by the applicant's experts. Well, they're intentionally influenced model parameters resulting in smaller projected CO2 plume results, resulting in avoidance of signing up landowners and keeping the money in their pockets.
Did you review the storage agreement that is part of the application?
I did.
And do you understand that you're going to be subject to the terms of that agreement, whether you've ever signed a contract with the applicant or not?
That's what it says. Yes.
Do you have any concerns with that or with the pore space lease attached to it that is purportedly going to be imposed upon you?
Well, as you've heard or seen, I should say, in testimony at this hearing, the resulting material changes agreed to by the applicant in the agreement that they committed to in this room this week, you're darn right I have concerns. We've been asking for some of that for 31 months. Yet the only way to get them to change the insurance provision of all silly things, something they have, they just didn't want to give us, was to publicly shame them in this room, in this hearing. What is up with that? Is that good faith negotiations? I don't know. The applicant's project does not meet the threshold for public interest as it pertains to a physical invasion resulting in a physical taking of our land. They have failed to provide any evidence of the mass balance of greenhouse gas emissions reduced by their project, if any, and substantiate that the direct and substantial impact to North Dakota citizens are required by law for physical taking. The applicant has not provided testimony of a direct impact on coal and power industries. The applicant has publicly stated that they will not be using the requested disposal facilities for enhanced oil recovery or other beneficial uses. They don't meet the policy recitals, and because of that, the storage agreement and these permit requests should be denied. Specifically, in the unleased pore space interests 3.1 section, any pore space owner in the storage facility who owns a pore space interest in the storage reservoir that is not leased for the purpose of this agreement and during the term hereof shall be treated as if it were subject to the pore space lease attached to hereto as Exhibit D. So I'm a pore space owner along with my wife Faye. We own interest in one of the storage disposal facilities, and it's not leased for the purposes of this agreement. What gives the state the right to make me an indentured servant to them, subjecting me to a private agreement that I don't agree to? Mr. Helms, are you the king and I'm the subject now? Once again, in your statements to the legislature on Friday, January 13th, 2023, you stated our future orders are going to be a little bit different. We're not going to incorporate the storage facility agreement.
Use of the surface. Now, we've learned through the asking of that question that our future orders are going to be a little bit different. We're not just going to incorporate the storage facility agreement that was privately worked out with the ratification people. In total, in there, we're going to address some of those issues. We're all
Sure seems to be included in this current storage agreement by my reading.
You have an understanding of whether you are going to have the same or a different lease as the North Dakota Department of Trust Lands?
My understanding is that the North Dakota Trust Lands has not signed an agreement to date with the applicant, but I do know that the lease version under consideration today is not the one in the storage agreement. So, do we not have equal protection under the law? Or is it the whole, rules for thee, but not for me? Typical of the king. Why does a state get a different lease agreement than I do? So, we've heard over the years, starting in this room, that they're simply trying to regulate our private property. But here they give the applicant the right to use as much as our land without requiring an easement that I've signed, without constitutional due process, and without that eminent domain hearing and jury trial. This is a blatant physical taking of our private property, unconstitutional. They're not setbacks. There's not safety considerations, noise, light, restoration, reclamation, or other written into the agreement. Yet, Mr. Helms, you told us that we would have that. Well, Derek, I might have lost it again. There we go. Yep, that's what's doing it, huh? All right, there we go.
So a very robust regulatory paradigm that you created, but it treats people fairly, it respects them, it runs things through multiple hearings. Man, have I learned a lot. So, one of the questions that's been asked is, do these industrial commission orders actually allow use of the surface? Putting a pipe or a pump or something like that on the surface. And yes, they do. The statute allows for reasonable and necessary use of the surface. Now, we've learned through the asking of that question that our future orders are going to be a little bit different. We're not just going to incorporate the storage facility agreement that was privately worked out with the ratification people in total in there. We're going to address some of those issues. We're also planning a rule change to make sure people understand that there are going to be setbacks, that you've got to keep this infrastructure that's on the surface away from people's homes and their businesses and roads and streets and streams and things like that. So, there'll be some rule changes. Am I looking forward to that? Guess what? Those rule changes have to go through EPA and be published in the Federal Register. How long will that take? I don't know. But if we're going to do this job right, we have to do it right. So that's our regulation paradigm.
So, I'd ask, are we being treated fairly? I'd say the obvious lack of due process would say no. Favoring Minn Kota over landowners is another egregious example of unfairness. Are we being respected? Well, I'd say no. The lack of reciprocal negotiations would say no. When are the other hearings scheduled that were mentioned? I only know of one. What statute references reasonable and necessary use of our surface? Where are these rule changes that Mr. Helms references? It's been 17 months since this legislative presentation, telling the legislatures so they wouldn't vote favorably on our Senate bill we had in process. What progress has been made to establish setbacks to keep these things away from our homes, our roads and streams, as mentioned in the video? You seem to put a lot of things in these storage agreements that aren't required by law. You certainly could put setbacks in it. I've reviewed the legislative history on 38 3822. That was a lot of fun. It's clear that the legislature did not intend in any legislative testimony or hearing to make us as non-compensated landowners subject to a private agreement we didn't sign. They just wanted us to get paid for use of our pore space in an equal manner. That's it. They also never intended the commission to require us to give up our surface lands, as the Century Code specifically limits the authority to pore space. As stated in Century Code 382210, amalgamating property interests, if a storage operator does not obtain the consent of all persons who own the storage reservoir's pore space, the commission may require that the pore space owned by non-consenting owners be included in the storage facility and subject to geologic storage. I don't see anything in there about surface lands. Not a thing. I don't see anything about our surface lands in that on which Faye's mom had to learn to do all the farming and ranching by herself and those activities after Faye's dad died while she was in high school. That same surface land provided wheat, oats, hay, and beef that were monetized to pay for Faye to go to college, where I met the love of my life. Those surface lands where my sons shot their first deer, their first pheasants, and their first grouse. The same surface lands that we host youth and veterans hunts every year on for our community. Those surface lands that the high school classes came out just this last month at 5 in the morning to sit in the cold and watch the sharp-tailed grouse dance on their lek within feet of their eyes, an experience that they will remember for the rest of their lives. The surface lands on which we almost lost one of our boys in a winter blizzard as he ran out to an open prairie field, disoriented from the hellacious winds and blinding snow, not able to see his mom standing in the garage door waiting for him. And it's the same surface lands that I've buried two of my best friends on. I did not hear anything about giving up access or use of our surface lands in that legislative directive. And it's not just the surface lands. You're affecting real people with your decisions from this hearing. Do you even know their names? Faye Beth Swenson, Joseph Oliver Swenson, Olivia Waswick, Warren Wayne Swenson, Courtney Geyser, Donna Mae Smith, Jewel Dawn Silbernagel, Dean Silbernagel, Craig Belinsky, Amanda Belinsky, Camden Belinsky, Mac Belinsky, Megan Summers Butler, Jeff Butler, Lauren Summers Gilmer, Chad Gilmer, Tammy Summers, Michael Bauman, Glenn Gerving, Lisa Gerving, Michael Haupt, Bonnie Haupt, Johnny Yoakum, Kevin Kraft, Kimberly Kraft, Charmaine Liebelt, Charlotte Liebelt, Kirk Mays, Linda Mays, Alan Mays, Paul Metz, Christy Metz, Gary Smith, Cassie Smith, and I can keep going all day if you'd like. But how many of them do you know? And do you know that your decisions will irreparably impact their land from your decisions from this sham of a hearing?
We take a break, Your Honor.
Yes, we can take a 5-minute break. Go off the record. We are back on the record. Attorney Broughton, you can proceed.
Thank you, Your Honor. Mr. Swenson, can you talk about any, you talked earlier about your experience with safety protocols in industrial settings. Can you talk about any safety concerns you have about the applicant's permit requests?
I can. And I'm not here to talk about the pipeline that's been given all the attention from a safety perspective. That's different. You know, everybody's worried about land shifting and the impact to the pipeline, faulty construction, whatever. I just want to make sure that it's on the record that CO2 is an odorless and colorless oxygen displacing gas that can be deadly at certain levels. And just to reinforce on the record that North Dakota Century Code 322808 states that before issuing a permit, the commission shall find that the storage facility shall not endanger human health. That's an absolute, there's no variation that they provide you. That's an absolute requirement to not endanger human health. High burden of proof shouldn't be taken lightly for the protection of human health. Unfortunately, the applicant has not submitted any evidence of a potential vapor release model, concentration gradients of the oxygen robbing CO2 that may be released, and its potential impact to public receptors into the record. Whether it's from an unplanned release or one of these little pressure valves or whatever we talked about yesterday. Without that, how can the state possibly say that they've met the statutory requirement and that burden, absolute burden, of finding these disposal facilities shall not endanger human health? Simply put, you can't. It's not possible.
Do you feel comfortable just trusting that after the process, the Industrial Commission is going to ensure that there are safety standards at some point?
I don't know if I do, probably not. I'm not sure that I have faith that, you know, even if the applicant were to have provided basic concentration gradients from a release with their application, even if it was under confidential seal, that the state would even know what to do with it, as evidenced by Mr. Helms' email dated January 15th, 2023, addressed to the North Dakota Senate Energy and Natural Resources Committee, as those members were considering numerous bills related to carbon dioxide pipelines, disposal facilities, and safety in general of a CO2 release. In this email, it appears to be his attempt to share his knowledge and expertise on modeling a release from a CO2 pipeline.
I'm going to hand you what we have marked as Exhibit LO 89. Mr. Swenson, I've handed you what we've marked as Exhibit LO 89. Is this a copy of the email you were just referencing?
It is
And how did you obtain a copy of that email?
from one of the members noted on there, Mr. Senator Jeffrey Magrum.
Move to admit LO 89.
Any objections?
No objection.
The exhibit is admitted.
Did you have a chance to review the information that was being conveyed to the legislators by Mr. Helms in this email, Mr. Swenson?
I did.
And did you do an assessment of whether you agreed with whether this was a accurate or predictive or even relevant model to be using in this situation?
I did. So at this time, which was during the 2023 legislative session, as I mentioned before, there were numerous bills going through the legislature. And as you can see in the way Mr. Helms introduces this, that it was, carbon dioxide pipeline information. There was discussion about the Satartia, Mississippi pipeline break that occurred, which caused a vapor cloud. And there was, and has been and continues to this day, a significant amount of concern about the vapor concentrations that were released and how they impacted the residents of Satartia. And I'm not here to discuss that, but what I am here to discuss is that Mr. Helms then, under that pretense of we're going to talk about vapor concentrations in an air dispersion model, unfortunately what Mr. Helms did is he used a risk management program overpressure model. It's not a vapor concentration model. It's not an air dispersion model as he promotes in his email to our senators that were making decisions on bills to protect public safety. That model is used for regulated substances and is used to determine off-site consequences to populations after an explosion, not a vapor release, but an explosion. So instead of predicting safe concentrations in the air of vapors, this model predicts what are called pressure rings from an explosion and determines a safe distance where the resulting blast ring is at 1 pound per square inch or less. This can be a very useful tool. I've used this tool in the refinery explosion scenarios where we looked at where should we build our maintenance shop, or how thick of concrete walls should we put on a building where our control room operators were, where they could experience a 5 psi blast. Where would a 1 psi blast get them? How about the public that's driving by on the roadway? That's what this model is used from. And it's very useful in the right application. Unfortunately, this has zero, zilch, not a thing to do with carbon dioxide vapor concentrations in air, which may affect human health. I don't know if there was a lack of critical thinking skills needed to realize that when the model didn't allow carbon dioxide, which is a non-flammable, i.e. it won't explode, chemical compound. In fact, it's used to put fires out. As a choice, he intentionally chose a different chemical, carbon oxysulfide. That's not carbon dioxide, but he does say that in the model. That's predicting a whole separate type of safety risk that CO2 doesn't pose. How can we possibly trust the state to find that this storage facilities shall not endanger human health if they don't even know what model to run? The state fails miserably on this point.
Mr. Broughton, I don't know if this is appropriate at this time, but could you, possible that you could add to LO 89 and include the email that went to Mr. Helms so we know what he's responding to?
Was there...
I don't know what email you're referring to.
It's because it's not on there.
Yeah, that's the point. I mean, this is an email from Mr. Helms to Jeffrey Magrum.
I don't see anything that indicates it's a response to anything, particularly an email.
Okay, probably right. I thought it was a response to an email. Maybe I'm wrong.
I don't know.
Okay, I'm sorry to interrupt you.
That's okay. You know, the sad part is, in addition to using the wrong type of model, they, in this permit application process, they don't even ask for the data on a release scenario. In an open records request to the state, they admit they do not receive information to evaluate this important topic on a prior permit application.
Can I have you take a look at landowner, or Exhibit LO90? Mr. Swenson, we've handed out Exhibit LO90. Can you tell us what this exhibit is?
I can. It is an open records request submitted February 25th of 24 to the oil and gas open records request email. Specifically, the email asks on those open records requests for all records relating to a carbon dioxide released to atmosphere from the storage facility and related equipment, including flow lines, compression, and well bore, that supports the finding that the commission made that the storage facility will not endanger human health as required by statute on the Blue Flint permit that was issued on May 31st of 23. It asked for the means and method of analysis, the scenarios modeled, such as releases from any pressure relief valves, the maximum release downstream of compression facilities due to flow line, pipe, flange, or valve failure, the weather assumptions for the scenario, such as temperature, humidity, wind speed, and direction, the name of the software utilized, the name, the employer, the certifications of the North Dakota Professional Engineering License of the person that did the modeling, and the CO2 concentration level delineation at which the commission has determined is safe for human health if there is a release, and the geographic topography assumed.
And what was the response from the DMR to that request?
On February 29th of 2024, a response was provided that dispersion models for specific release scenarios from the storage facility isn't information that is provided to our office, but it does include an emergency and remedial response plan, which discusses the necessary actions that the storage operator will take during a potential emergency event, including the release of carbon dioxide from the storage facility, whether it be from wellbore integrity failure, flow line leak, or other storage equipment.
Move to admit LO90.
Any objections?
Object on relevance foundation. Mr. Haupt isn't here to answer any questions of ours.
Your objections are noted. The exhibit is admitted.
Do you have any concerns about this response to the record request and the positions taken by the state regarding human safety?
Well, obviously it's important to have an emergency response and remediation or remedial response plan, sorry. But that just tells you how you're going to respond to where the dead bodies are from a vapor concentration that exceeds the IDLH standards that our federal government sets. It doesn't tell you, are you designing the facility properly? It doesn't tell you what my setback should be. It just says, here's where the ambulance should go, and here's who we're going to call to go gurney out the dead bodies. The applicant did not include in this hearing process any data with these applications under consideration for this matter, and the state presumably has not asked for it. We haven't received it, and we can't verify this. Well, as our deposition requests and discovery requests have been ignored by the applicant and unenforced by the state of North Dakota.
Objection to that, Your Honor. The requests have not been ignored. There's currently motions pending, and the applicant intends to respond.
Overruled.
The state will tell you they have a setback of 500 feet, and that's highly adequate, as they have used it for oil and gas wells for many years. Yet, what they won't tell you, this setback was determined from a study of idling diesel trucks that has nothing to do with a natural gas or crude oil release, let alone a deadly CO2 vapor hugging the ground, looking for the children playing in our creek bottom while they're hunting for frogs. For these safety reasons, these permit applications should be denied.
And in general, Mr. Swenson, do you believe that the applicant's request should be approved?
I think they should be denied. We've been highly prejudiced due to the lack of adherence due to North Dakota rules of civil procedure and the state's failure to hold the applicant accountable to our requests. And honestly, Mr. Broughton, they're simply setting themselves up to waste more taxpayer money on a due process lawsuit pending their decisions made by the people in this room on these permits. So as I discussed earlier, the applicant has refused our depositions and discovery requests. We have had no information provided from them for us to properly prepare for this hearing. While in bed with Summit, the state has denied us as interveners a fair hearing and our rights of due process guaranteed in law. While they are asleep at the wheel, our game clock was run down to 20% of the time remaining, severely prejudicing us with lack of due process. We put our petition to intervene in 2 days after the notice came out, and you wasted 80% of our time to prepare by not granting us our petition to intervene. How is that a fair hearing process? How is that due process under the state's procedures? The applicant has testified they intentionally adjusted model parameters to reduce the size of the CO2 plume. Additionally, they intentionally set the boundaries of the storage facility smaller than where CO2 will be present. When they find that the storage facility is too small, the applicant has testified that they have no plan, and they wouldn't commit yesterday by Mr. Basance to even compensate these new landowners.
Objection, mischaracterization of Mr. Bassan's testimony.
Read the record.
Any response?
The record will speak for itself. We'll have a transcript.
Overruled.
For these reasons, the commission can't possibly find, as statutorily required, that pore space owners are compensated equitably because they don't even know who all the pore space owners are, and that they should be, who should be paid, and that the applicant has no plans to pay for them. Let them, let alone be paid just compensation guaranteed by our Constitution in this physical taking of private property. The commission can't possibly find that these disposal facilities shall not endanger human health when the applicant hasn't provided CO2 vapor dispersion modeling from a release at each of the disposal facilities. They have no idea how far a major leak will travel, potentially endangering human health at public receptors. Hopefully someone in the state can find someone to run a dispersion model with the correct chemical compounds and a model that predicts vapor concentrations and not blast ring pressures. The applicant has failed to fulfill its obligation of proving the requested permits are in the public interest. And finally, I'm gravely concerned about this sham of a due process that our state has allowed. Not only has the applicant put forward tremendous effort to get here today, but North Dakota the state of North Dakota has put in tremendous time, resources, effort, taxpayer monies into laying the framework out for this industry that could lead to great things for our North Dakota industries, the workforce, economy, citizens. But unfortunately, due to the state's lack of action, denial of our due process, as an affected party, as an intervener, you're jeopardizing a future lawsuit that's going to likely end in the EPA removing North Dakota's primacy for Class 6 injection well programs. Is this the legacy you want as you go into retirement? Is this your swan song? I fucking hope not.
Well, I don't have any further questions for this witness at this time.
Okay, we're gonna break here for lunch. Attorney Broughton, I would hope that on cross-examination you can control the witness.
Yes, Your Honor.
We'll break here for lunch, off the record. Okay, we are back on the record, and we will begin with cross-examination of the previous witness. However, there's been a request for a statement.
Yeah, Mr. Swenson would just like to say something briefly before the cross-examination.
Thank you. I'd like to just apologize to the oil and gas folks that are here, and to you, Mr. Gardner, for my choice of words at the end of my testimony, and any condescending tone that I had towards individuals. As you can imagine, this has been a very emotional experience for us personally, for me, the family that I love and will protect till the end, our land and the landowners that have been affected. So thank you for allowing me to make this statement.
Thank you. Attorney Goot, you may proceed.
Thank you, Mr. Examiner. We have no questions.
Any questions from the staff?
Kurt, in your experience working for different industrial companies, do you believe in a company like Summit can operate this facility safely?
I've been part of a startup organizations a couple of times, like they have, and built businesses like they're trying to build, not pipeline. I don't know enough about the people in the company that they're hiring to operate. Thank you. But it is possible. We have done it ourselves, and I think they have every chance to do it if they put the right people in place, the right procedures and design and all that.
Okay, thank you.
Kurt, I'm looking at your exhibit LO89. Did you have a conversation with Senator Magrum about this email?
As you'll see, Mr. Helms, on the exhibit, it's dated Monday, June 10th, 2024. So I had talked with him on Monday, and he had forwarded it to me on Monday. It wasn't actually, I had asked him for some other information, and he sent me this one that was related. Yes. So I did talk with him.
And what did he tell you about the context or the what initiated the email?
What he generally, and I am not quoting him here, but generally what I was left with was that it was in regards to the time when there was pipeline bills being introduced in the legislature, and that it was in relationship to the safety of the pipeline being proposed, in this case, by the applicant in the Public Service Commission ultimately, and the rules that were, or the Senate bills at that time that were trying to be passed that affected setbacks and county ability to adopt ordinances or changes that they desired. So it was kind of in that context, Mr. Helms, and it was about, how far does one have to be safe from the pipeline, is the impression that I was left with from that conversation. But you may have to ask him specifically, but.
Were you present at the January 15th, 2023 Senate and House Ag and Energy Resources Committee meeting?
I was not at the joint one that we played.
Yes.
The video from that one. I was not personally present. I had watched it in its entirety on the legislative website that allows you to see those things, but I was not present.
Your exhibit LO63. You indicated that we could see some white areas, but my copy doesn't show any white areas. What,
Is that the map?
I'll pull it
it's
up.
a map.
Yeah.
LO Intervenor Properties.
It might be a cream color.
Oh, okay. My
Maybe.
vision color might be slightly off, but we'll take a look here.
Oh, I think it's how it printed. What is it? What number?
Oh, yeah, that looks different than the electronic one, slightly, color-wise.
Yeah, let's look at the difference here. Okay, yeah.
So the white areas that I was referring to, Mr. Helms, if you were to look on the legend, down where it says Swenson,
Yep.
towards the bottom, that in particular looks white, and that's what I was referring to. I'm guessing what happened is when the overlays went on, it slightly changed because of the multiple layers, and so the areas, if you'd like me to point them out that I was referring to, I can.
Well, either that or submit a supplement that brings those to the front, so.
So,
it's-
so,
No,
so,
stop.
oh,
But the way it is, it isn't useful for your testimony.
Okay, you don't need to say anything.
Can you submit it electronically?
We're not going to submit any supplements.
all right.
The legal descriptions for each intervener landowner are itemized in declarations with the deeds attached, every encumbrance on the property, and the legal description.
Yeah. That's all I got.
Okay, Mr. Broughton, you can call your next witness if.
I am not going to call any more witnesses. I'm not going to rest my case. I renew my objection to the timetable on which this hearing was held, the lack of notice, the inability to get information from both the agency and the applicant. So I move once again to continue this hearing until a later date after we have had time to obtain the data and to prepare for a hearing. And given that the applicant apparently doesn't have a complete application yet, I think that's going to be required anyway. So I'm not trying to be difficult, and I know everybody wants to go home, and I do too. So I'm not trying to make people stay here, but I'm not going to rest. I'm going to put my objection on record and move to continue.
The objection is noted and your motion is denied. This time then, I think we can move with public comment. Okay. Let's try to keep this as orderly as possible. Do we have a sign-in sheet? We don't,
There was one at the table. If there's nobody signed
because I could
up.
call people individually. Nothing? Okay, at this point, I'll open the floor to anyone who'd like to come up and make a public comment. Okay, I'll note for the record that no one,
He's coming.
oh, I'm sorry.
Kind of slow.
No, that's fine. Please state your name for the record.
Kenneth Emo Hens.
Okay, you may proceed.
Kenneth Emo Hens.
Okay.
I'm a landowner in Oliver County. Would you like a legal description on my property in Oliver County? Is that necessary? Okay, so the legal description of my property is the northeast quarter of section 9, 14286, and the northeast quarter of Section 17, 14286. As a landowner in Oliver County, I support the Summit Carbon Solutions project. The project would provide new industry for North Dakota, supplemental income for farmers and ranchers, and new tax dollars for the county. I have dealt with them since 2021, and the overall experience has always been very good and open. Thank you.
Thank you. Anybody else? Okay, then before we go off the record, we have a number of supplementals that we're going to need to keep the record open for. Attorneys Bender and Broughton, how long do you think you need to keep the record open?
I think we can have all the supplementals back to the commission by June 24th.
And one of those includes an amended storage agreement, which is probably going to require you to work in conjunction. How long, can you have that in the same time frame?
Yes, we can have everything to you by June 24th.
Attorney Broughton,
I presume so.
June 24th? All right, we'll leave the record open until June 20, oh, go ahead.
Just making sure you're also going to address the written comments
Oh,
and
yes, I did receive 2 emails. One in support of the application, one in opposition. I note that the emails came in after 5 o'clock on Monday, on June 10th. Any objection to admitting those into the record?
I don't have any objection, Your Honor.
No objection, Your Honor.
Then we will admit those emails into the record as well.
Okay.
Anything further?
Go ahead.
there was also the number of written comments received prior to, I guess, is there a response from either party to any of the written comments received prior to the hearing?
I'm not sure that I understood what you're saying, Rich, I'm sorry.
Any objection to them in the record or response to any of the content within those?
Well, I don't know, I haven't had an opportunity to review them carefully. Perhaps you could leave the record open additionally for responding to the letters that are coming into the record until June 24th as well. If that's not inappropriate, Mr. Examiner. That's what we would propose.
Any problem with that? Okay. Then we will leave the record open until June 24th for that purpose as well.
I don't think you're going to get a lot of response from us, but it does give us that opportunity, obviously.
Okay.
I do have one matter, Mr. Examiner. This is probably because of my poor record keeping, but I did put together a list of the exhibits that we discussed. I could give Mr. Broughton a copy and you a copy as well, and maybe it's something that we can all look over in the next day or so. And I don't know if Mr. Broughton plans on providing us with one, and then we can decide if all the exhibits are in. I don't want a situation where, we talked about an exhibit, it's clear that it could be entered, but we forgot to offer it and it wasn't admitted. So if Mr. Broughton doesn't have any problem with that, I can provide my list now, and I don't have any problem if Mr. Broughton wants to supply his with a copy to me in the next couple days so that I'd have an opportunity to respond.
I think that's a great idea, I agree.
Okay, that's fine.
I guess to the effect that there were supplementals requested by commission staff, are you confident you have a list of the items that were requested and or indicated would be submitted as supplementals?
I am, but I'm prepared to provide you with a list of what we believe needs to be supplied. I can submit that to you and copy Mr. Broughton. And obviously, if you think we missed something, perhaps you can just respond in an email, certainly copy Mr. Broughton.
Yeah, that works for me. I appreciate that.
Okay, thank you.
Anything further? Okay, that concludes our hearings for case numbers 30869 through 30880. Concludes our hearings for the day.